Hi all, and welcome to the next seminar in our online program for the COVID-19 crisis that we're all experiencing now. Hopefully you can all hear me. If not, on the next slide, there's a little bit of a information about how you'll send a question. It will also come up with a message to our moderator. So if you are having any troubles with hearing or seeing any of the video, please send a message off to our moderator, who is Carolyn, and she'll see what she can do to help you. Now, if you do want to ask a question during the webinar, we are going to answer all the questions at the end. So feel free to type in your message as we go along, and they will all just come up in the end once we've finished speaking. If you can't see that little screen, you might just need to open your, I guess, little box where you deal with your video and audio settings, and it should be in there. But otherwise, onwards we go. So for those of you that don't know me, my name's Sheelagh Gray. I'm a senior lawyer in the tax structuring and planning section of our firm. Today you'll be hearing from me, and you'll also be hearing from Ben Gouldson, who's the director of the firm and also works in our section. I believe you can see him up in the other corner. So we're the two stars of today, but please feel free to pick our brains as required. Now, because we're lawyers and we can't go anywhere without disclaiming what we are about to tell you, here's our disclaimer. Obviously, it's any advice that we give you today is specific. It's not generalised. It's not advice for your particular legal circumstances, so you need to seek further legal advice if you have any concerns about what we raise, or if you want more information that we can make fit your circumstances and especially for you. So hopefully we won't come across anything too hairy in that, but otherwise that's our disclaimer. So onwards and upwards. So today, in today's webinar, we're basically going to be discussing two main areas. The first is changes to your estate planning and what COVID-19 means to that process. There's some issues that we need to get around, and what are the legislative changes that have been adopted to assist with that. And I'll be discussing that. And then secondly, Ben will take over and he'll be discussing managing risk during and beyond COVID-19. So that's a little bit about what you might be able to do now and what might serve you well into the future, just about quarantining any risk for your business, transferring IP assets to enable use beyond an inverse insolvency event should one happen to you because of COVID-19. Whether or not implementing a holding entity might be suitable for your business, and legislative changes, what has come in and should you use them, also whether or not they will actually apply to you. So let's get started. So on the next slide is just which is headed reviewing your estate planning, and hopefully you can all see that. When should you review your estate planning? When should you review or update your estate planning documents? Sorry. If you have estate planning documents with us, you're no doubt aware that we have an ongoing program where we sort of recommend that you update your estate planning documents or review them at least every 3 years, and that we send you out a letter that sort of, I guess, goes along with that. It's especially important to review your estate planning documents if your circumstances have changed, and this might be for any reason, not just COVID-19. The easiest ones and the most common ones that we will talk about is, have you married or divorced? Are there additional children that we didn't make provision for in the last will? Has there been a change to your name or the name of anybody else mentioned in your will? So one of your children may have got married, for instance. If an executor dies or becomes unable to act due to age, ill health, or if a beneficiary dies, or if you have specifically left any property in your will which you subsequently sell, or its changes in nature. So regardless of the circumstances, all of these remain true. And we're always happy to discuss any possible changes that you may have if you are concerned about your documents. But I guess in the with respect for today, our main focus is on a change in circumstance. and look, I guess currently this is true for a majority of people. We don't want to cause alarm or cause you any unnecessary concerns, just because your circumstances have changed with COVID-19. A change in work, a change in your business may or may not require a change of your will, but it's certainly a good time to get out your estate planning documents and have a read of them. Look, a review can be as simple as reading over a copy of your documents if you've got them and ensuring they adequately record your wishes. If they don't, or if you don't have a copy of the documents, you can always contact our office and we can get a copy of those to you for you to review, just to make sure that everything's okay. Obviously, this review is probably a bit more urgent and a bit more important if you have in fact married, separated or divorced, as those actually events will revoke your documents either fully or partially. Look, I won't go into today exactly how that works. Just take my word for it, because I'm a lawyer. But look, the reality is that there are some significant changes that will happen if that's occurred. Also consider at this time whether there have been any specific changes to your entities that reflect the COVID-19 changes. Have you changed your trading entity? Have you stopped trading in an entity? Are there specific provisions about those sorts of entities in your will? Because if there are, then we may need to have a look at them. So look, I guess the main focus of today is to suggest that you review and seek advice. If you do need to change your documents, the biggest concerns for us as legal practitioners, but also as people who want to keep our clients safe, is what is a valid document in these times, and exactly how do we go about ensuring that your documents are valid at this point. So unfortunately to date, there's been no changes in Queensland which have considered the formal requirements of signing these documents. What that means is that the current legislative requirements of a formal will and a valid EPOA still stand. And generally what that means is, for a will, that it contains a revocation clause, that an executor is appointed, that it gives away your assets, and that it's executed correctly. For an enduring power of attorney, that means that the principal understands the power they are trying to give away or give to their attorney, when that power will commence, and how to revoke that power if necessary, and again, finally, that it is executed correctly. In these current times, thanks to the social distancing and other restrictions placed on us with respect to COVID-19, the biggest issue is around the execution and correct witnessing. Because there's been no change to the legislation, a will still must meet with when signing a will, you still must meet with 2 independent witnesses. And for an EPOA or an enduring power of attorney, you must still meet with a qualified witness to ensure that your documents are valid. So at Clifford Gouldson Lawyers, we're doing what we can to work within these requirements and the social distancing rules that have been set down, and we're still seeing people in our office or at a suitable other location, but we're taking, I guess, some extra precautions about how that appointment is carried out, and to the extent or what we can do with respect to ensure that we're all kept safe. So what happens if you have to get documents witnessed and you can't get to us to do that, which is obviously the big concern that probably most of you will have. So what that means is that you will probably end up with an informal will, and there are some issues associated with that, or an invalid enduring power of attorney, and there's some issues associated with that. Basically, I'll quickly talk about informal wills, and there's 2 sort of areas to cover here, and they're slightly different. However, we're working, I guess, to manage those in a fairly similar way. So if your will isn't correctly executed, it becomes what is called an informal will. The only way to have an informal will validated after death is by the court, being the Supreme Court of Queensland, and this is known as a Section 18 application. As you can imagine, having to seek the court's validation causes some issues around costs and uncertainty for your beneficiaries and other people who are having to deal with your estate once you've passed away. This is mostly because Section 18 says that a court may dispense with the execution requirements if they have a document that purports to state the testamentary intentions of a deceased person, and the court is satisfied that the intended document is to form part of a person's will. Now, obviously, it may be difficult to determine that whether or not the document that is in question is in fact purported to be someone's will. So the legislation goes on to say that the court can have regard to any evidence which relates to the way in which the document was executed, or any other evidence that's available with respect to a person's testamentary intentions. So for us, we will be working towards you, obviously, to get a formal will. If a formal will is not an available process for us at the time, we'll be taking steps to ensure that the evidence we have supports the document being your last will, so the court can easily make those sorts of determinations that they believe it's your last will, and then we can provide them with evidence as to why it was an informal will rather than a formally executed will. And I'll go on at the end just to talk about how we're managing that. The other issue that comes up with a will that is informal, or in fact not at all signed, is that it may be considered that you have died intestate, which basically means you have died without a will. Again, this is something that we would like to avoid if possible, although it results in a similar effect insofar as the court will be required, there'll be a required application for the will to be validated or for letters of administration to be issued. So that's, I guess, the main issues around an informal will or or not having a will at all. With a enduring or an invalid enduring power of attorney, if you have no witness, it is not a valid document. Which basically means that should something happen to you during this time, no one can make a decision for you if you lose capacity, which can be problematic, obviously, if something happens to you. Again, the only way to rectify this situation is with an application, in this instance, to the Queensland Civil and Administrative Tribunal, and requesting that a person be appointed into this role for you. This, again, is just another step and I guess quite intensive type of application someone has to make on your behalf, and bearing in mind that the current restrictions during COVID-19 also apply to tribunals, so there may be some delay in getting all of that done. So what are our plans to manage all of this? Obviously, we're going to continue with the formal requirements up until we absolutely cannot. So we will take whatever steps we need to ensure that we can meet with you with the social distancing protocols in place, so that we can ensure that your documents are valid. If there becomes a situation where an informal will is required because we cannot meet with you, or you do not wish to meet with someone at this time because of your own health issues, we plan to basically have a system whereby we have a video conference or similar set up, so that we can witness you signing your will. We will record that. As soon as possible after the restrictions are lifted, we will sign a set of formalised documents. However, if something were to happen to you and you were to pass away, or you were to lose capacity before we could sign those formal documents, we're going to implement a system where we get you to send us that document that you have signed, send a letter to us, which we will provide to you, and you just need to sign to say, this is my will, this is what I intended to do. When we have that coupled with our video recording of you signing it, we believe that that will make any application that we need to present to either a court or a tribunal very smooth and much less of a issue for the people that might be making those applications on your behalf. Obviously, that's not ideal, but it is what it is at this point in time, and we'll make sure that we can do what we can. So, Obviously, it's not all doom and gloom, and we will be able to expect some things moving forward. Probably the most interesting part around here is that New South Wales has actually put into effect a piece of legislation that permits amendments to the signing of documents under their Oaths Act, their Succession Act, Power of Attorney Act, Guardianship Act and Conveyancing Act. At the moment, it's just an overriding piece of legislation which says that they can enact other pieces of legislation to change the way those documents must be signed and still remain valid or formal documents. So we're keeping an eye on that to see whether or not anything happens in New South Wales and using it as a guide until such time as Queensland might enact a similar piece of legislation. Queensland Titles Office has changed some of their signing requirements. They have now agreed that certain video conferencing and signing of documents by separate people, as long as they are the people who actually were in the video conference, will be acceptable to titles. So we'll keep an eye on any further developments there. And look, I guess we're really hoping to see some change in Queensland around these signing of other documents if this situation goes on for much longer. In the meantime, we'll work as best we can to ensure that you and your documents are valid, and that we have evidence of your intentions if we can't get a valid document, so that we can put it before a court. So that's, I guess, a very quick summary of my part of the talk today. I appreciate I ran through it very fast, but we need to leave some time for Ben. He's got some other important stuff to talk to you about. So I'm going to hand over to Ben now, and he'll discuss the managing the risks for your business. But as I said, if you have any questions, pop them through and we'll answer them all at the end. Thank you.
Thank you, Sheila. Good afternoon, everybody. I hope you're all staying safe and well and following the advice of our government. Obviously, it's an uncertain period and we're really not sure how long this isolation, distancing and the lockdown will last. I think we need to be fairly conservative and we probably need to plan for the lockdown to continue for the 6-month time frame that some of the legislative changes have already enacted. So you've got some changes in the Parliament that have come through around the job keeper, the job seeker, around bankruptcy and insolvency deadlines that are 6 months in their passage through Parliament. So I think if that's what has occurred, we ought to make plans based on that, whether it is truncated or extended. We can react as we need to. So what I thought I'd start with today is just a conversation around how might a business owner go about quarantining any risk that COVID-19 might be causing or presenting to their business. And the first step in that, I think, was let's have a talk about how your business is currently structured. What is your trading entity? And is it the same entity as your employing entity? And where do you hold your significant assets, including your intellectual property? I think it's fairly common these days that because business owners rely heavily on their lawyers and their accountants and sometimes their bank managers and financial planners for advice, they don't necessarily have a very clear understanding of the way that their business is structured. So I think that's the first step. The issues that might flow from your current business structure might include needing to identify for JobKeeper lodgement, registration, and then claims. Well, which entity is it that lodges your BAS? Which entity is actually eligible for JobKeeper payments? Which entity actually enters into supply contracts and therefore has the exposure to the liabilities to make payments under those supply contracts or to meet obligations that are due contractually in the context of those supply contracts? And when you're also having a look at that, we need to consider what security has been given, whether it's to the financiers whether it's to those suppliers, who has given some kind of security, whether it be land, whether it be personal guarantees, or some other form of cross-collateralisation. So they're the issues that need to be considered after you've gone through that process of identifying how you operate and how you trade. If Carolyn can move to the next slide, please. Thank you. So once we've identified where the entities lie and which ones are the trading entities and which ones might not be, we can then have a think about, well, okay, is there a risk? Is the COVID-19 impact on our business such that we are worried in the next 6 months we may not get through this? Now, a lot of businesses have an immediate impact. Those frontline businesses that might be in retail food, in that sort of transportation and logistics, or education, peripheral services, you might see it immediately. There are other businesses who might see it on a lag basis, where your revenues decline over a period of weeks or months. And so having regard to which type of business you are, or you're advising clients in relation to, it's worth thinking about whether or not you want to consider transferring intellectual property assets, including your brand, your logo, any copyright, any designs or trade secrets or patents. It's worth thinking about whether or not you want to take steps to protect those IP assets. That, if you do so, may enable you to trade on and relaunch under a new entity after the COVID crisis is through and finished, and we're across that bridge that the Prime Minister continues to talk about, and the Treasurer raises as well. And sometimes that happens. There are a number of businesses in the Darling Downs marketplace who people wouldn't even know went to the wall. They held their brand and logo and other assets separately in a different company than their trading company. The trading company shut down and they were able to launch again. Now, it's not ideal. It's not something you really want to go through, and you've got to be careful and get specific advice before you do that, because there can be some voidable transactions in the mix. But it's worth at least thinking about. The next thing to think about in that context is what regimes might exist to help you through this difficult time. And I think it's worthwhile mentioning the 2017 safe harbour regime that came through and has been operating for a few years now. It hasn't been considered by the courts at all, so there's no judicial guidance for us. But what we know is that the directors in that case will have the onus of proving that they developed one or more courses of action which were reasonably likely to improve the creditor's position. That is the position of all of the creditors of the company that goes to the wall, and that the debt was incurred in the furtherance of the course of that action chosen. So that's an existing safe harbour regime. After COVID came in, the Commonwealth Government then enacted a COVID-19 regime, which enables directors who can prove that they incurred a debt during the ordinary course of business between 25 March and 25 September 2020, and which were incurred in the period before entering into any administration or liquidation, the directors will not be liable for those debts. So just to recap, ordinarily directors have to trade companies solvently. If they don't, and they incur a debt when the company couldn't meet the debts as and when they fell due, they ordinarily would be exposed to a personal claim for that debt to be paid. These regimes effectively enable a director to avoid that personal liability if they can prove each of the issues that I've outlined in that slide. So keep that in mind as we're moving forward, whether that's borrowing more money to continue to survive the COVID period, whether that's extending terms of credit, or continuing to employ people, engage people, purchase stock there are some relief mechanisms to avoid that personal liability for directors. Okay, Carolyn, next slide, please. We obviously know in structuring businesses that there are some tax advantages depending upon what profit a business might make. So this slide just simply sets out the personal income tax rates in the recent past, currently, and then moving forward. I won't labour this slide, it's just there for illustration purposes to identify that the tax rate can be nil, 19%, or 32.5% and above. Now, if we go to the next slide, we can see that when a company is involved, I've assumed for this exercise a 30% tax rate, but obviously for some companies it's 28% if you're a particular small organisation. And this is simply illustrating that a company earns its money, pays tax on its profit, and there is available a franking credit for the shareholder of the company, so that if the shareholder's tax rate is less than the 30 cents in the dollar, you may well be in a win-win situation where you can save tax. The background of those two slides, if we move to the next slide, we can then see an ideal trading structure. Now, this is of course very generic, but in a circumstance where you've got your trading company exposed to the risk of trade that I was talking about before, you might have another company that's a holding company, whether it's an intellectual property holding company or an asset holding company, doesn't really matter. The theory is the same. It may well hold the assets and license them to the trading company for use in trade. All of the trading risk sits with that trading company, and those assets are held safely. And that's something that I think we need to think about at this current climate, where our trading companies might be exposed to some significant additional risk as a result of the COVID-19 crisis. The shareholders can be common, and certainly that can facilitate some streaming of some income if it's a family discretionary trust. But even if it's not, the asset protecting strategy operates effectively. Next slide, thanks, Carolyn. So the current changes I just wanted to make you aware of in the context of what I've spoken about is $5,000 is increased to 20. So if you want to issue a bankruptcy notice against a private individual, it has to be now over $20,000 worth of debt owed. And instead of them having 21 days to pay, they now get 6 months to pay. Statutory demands is the same. It's got to be 20,000 now, not 2,000, and they get 21 days to respond. And they used to get 21 days to respond, now they get 6 months. So what does that mean for us in business? Well, it probably means cash is king, and you're probably going to see a lot of businesses holding cash longer than they otherwise might have, principally because the sticks that could be held over their heads are not so powerful in this context. So keep all of that in mind when you're thinking about the structure through which you trade and whether or not there's some steps you want to take independent legal advice and accounting advice around as to whether you should transfer those assets from a trading company out to an asset holding entity to protect them from an adverse event. Next slide. So, upcoming webinars, back to you, Sheelagh. I'll let you finish and close out.
All right. Well, it seems that we don't have any questions at this point in time, so I'm just going to assume that Ben and I have wowed you with our presentation today. But if you do have a question that you just haven't been able to type in, or you want to talk to either of us directly, we're more than happy to have a quick chat with you just about something that might be concerning you at this point in time in relation to either documentation or business risks. We do have some more upcoming webinars in this series. So on this Thursday, Simon Playford, who's the lawyer in our new offshoot of our firm called Bolter is going to talk about new business and new opportunities and how you might be able to, in fact, come out ahead of the COVID crisis and, you know, transferring to other types. And then next Tuesday, Kylie Howell's going to go through construction contracts, which might be especially aimed at those people who are working for people in the construction business, but who also just need to know what the changes in the regimes might mean for them. I'm sure they'll be fantastic. I don't know anything about them, but I'm sure they'll be fine. So that's basically it. We have, as you're probably aware, had some previous webinars. There's 4 earlier ones. They're all available on YouTube, and that's the, I guess, names of them there on that screen. If you're having trouble locating them, if you are like me and maybe technology is not always your friend, please feel free to contact the office and we'll direct you through to our marketing team, who will possibly be able to send you a link or direct you exactly where you need to go. But look, that's it for today. Thank you for joining us. I hope you learned something. Feel free to join in for the next ones. We'll be pleased to help you wherever we can, and we'll see you later. Thanks very much.